The United States Department of Justice just walked into a federal courtroom and declared that Massachusetts is flatly violating the Second Amendment by banning firearms that Americans legally own everywhere else in the country. This isn't speculation. This isn't partisan spin. This isn't some advocacy group making claims. This is the federal government saying officially, on the record, in legal filings that will shape constitutional law, you cannot ban guns that are in common use by law-abiding Americans, and Massachusetts has crossed that line. It happened in February 2026, and almost nobody is talking about it, which should tell you everything about how media priorities work when the narrative doesn't fit their preferred story. The DOJ just filed a bombshell amicus brief in federal court supporting gun owners, supporting firearms dealers, and demanding that Massachusetts' entire handgun approval scheme be struck down as unconstitutional. If Massachusetts loses this case, and they should lose based on existing Supreme Court precedent, the ripple effects will be absolutely massive for gun control regimes nationwide. Every gun owner in America needs to understand what just happened, why it matters, and what it means for the future of Second Amendment rights that state governments have been systematically destroying through bureaucratic schemes designed to make constitutional rights impossible to exercise. Subscribe to this channel right now and turn on notifications because what comes next exposes how states have been violating your rights for decades while pretending to comply with constitutional requirements. The case is Granada versus Campbell, and it's currently before the First Circuit Court of Appeals after a lower court shamefully upheld Massachusetts' gun control scheme. The plaintiffs include a Massachusetts gun owner who's being denied access to firearms he has every constitutional right to purchase, a firearms retailer who's being prohibited from selling legal products to legal customers, and the Firearms Policy Coalition, which has been doing critical work challenging unconstitutional gun laws across the country. They're challenging what Massachusetts dishonestly calls an approved firearms roster, a system that requires state government bureaucrats to pre-approve what handguns you, an American citizen, are allowed to purchase. If your chosen handgun isn't on their approved list, you're completely out of luck, even if that exact same firearm is perfectly legal in 49 other states. Think about how absurd that is. A firearm can be legal everywhere else in America, manufactured by reputable companies, used by millions of law-abiding citizens, including police officers, and Massachusetts can simply declare, "We don't approve of that one," and ban it from commercial sale within their borders. Here's the key development that just changed everything. The Department of Justice is now backing the gun owners and explicitly urging the court to reverse the lower court's ruling that upheld this unconstitutional scheme. The federal government is telling a federal court that Massachusetts is violating the Constitution and they need to stop immediately. Massachusetts claims this roster system is about safety, but we need to be absolutely honest about what's actually happening here because the pretense has become insulting to anyone paying attention. Under Massachusetts state law, every single handgun must meet arbitrary design standards created by bureaucrats who often have zero firearms expertise. Each model must pass state-mandated testing that has nothing to do with whether the gun actually works safely and everything to do with creating obstacles. And each firearm must be placed on an approved roster before any licensed dealer can sell it. If your preferred handgun isn't on that list, licensed gun stores are legally prohibited from selling it to you. Not because it's dangerous, not because it's defective, not because there's any evidence it poses unusual risks, but because Massachusetts bureaucrats decided to say no, and under their system, their arbitrary decision is final. There are other states operating identical schemes, which is exactly why this case has implications far beyond Massachusetts' borders. The DOJ didn't mince words in their brief, and they called Massachusetts' system exactly what it is: a pre-clearance regime that bans arms in common use, which the Second Amendment flatly forbids under multiple Supreme Court precedents. This entire case turns on one foundational constitutional principle that the Supreme Court has stated repeatedly: arms that are in common use by law-abiding citizens cannot be banned by government at any level. That principle comes directly from Heller, MacDonald, and Bruin. the trilogy of cases that supposedly settled Second Amendment law once and for all. The Department of Justice spells it out with crystal clarity in their brief. Governments may not accomplish indirectly what they are forbidden to do directly, and that means you cannot ban commonly used firearms through regulatory schemes any more than you can ban them through outright prohibition. Massachusetts tried to argue in court that they're not actually banning guns, they're merely regulating how firearms are sold within their jurisdiction, and that distinction supposedly makes their scheme constitutional. The DOJ responded that this argument is constitutionally meaningless, and they're absolutely right. If the practical effect of your law is to prevent people from buying firearms that are in common use across America, then you are infringing on the Second Amendment regardless of how you characterize what you're doing. Period. This matters enormously because it cuts through the semantic games that gun control advocates have been playing for decades. They claim they support the Second Amendment while passing laws that make it impossible to actually exercise Second Amendment rights. Then they point to the technical structure of their laws and claim they're not really bans. The DOJ just rejected that argument entirely and said courts must look at actual effects, not just legislative characterizations. If your law stops people from acquiring common firearms, it's unconstitutional, no matter what you call it or how you structure it. Now here's the part that should infuriate anyone who cares about constitutional rights. The lower court that initially ruled in favor of Massachusetts said gun owners can simply purchase these banned firearms outside of Massachusetts and bring them into the state, so there's no real burden on Second Amendment rights. The Department of Justice absolutely torched this logic, and their response deserves to be quoted extensively because it demolishes one of the most pernicious arguments in modern constitutional law. The DOJ stated clearly, the Second Amendment is not a second-class right that can be burdened simply because people might find workarounds. Forcing citizens to leave their state of residence to exercise a fundamental constitutional right is not constitutional compliance. It's constitutional violation. Imagine applying this reasoning to any other constitutional right and watch how quickly it becomes obviously absurd. The government could tell you that you can't publish a particular book in your state, but you're free to travel to a different state and publish it there, so your First Amendment rights aren't really being violated. They could tell you that you can't practice your religion in your home state, but neighboring states allow it, so your religious freedom is intact. They could tell you that certain political speech is banned in your jurisdiction, but you can always move somewhere else if you want to say those things. Every American would immediately recognize these scenarios as flagrant constitutional violations, yet courts have been accepting this exact reasoning when applied to Second Amendment rights. The Department of Justice explicitly states in their brief that this reasoning violates Bruin and effectively transforms the Second Amendment from a guaranteed right into a revocable privilege that exists only where state governments feel generous enough to recognize it. Constitutional rights don't work that way. You don't get to ban fundamental rights in certain geographic areas and then claim you're respecting the Constitution because people can leave those areas. That's not how American constitutional law functions, and the DOJ is finally saying so officially. Massachusetts tried deploying another manipulative argument that gun control advocates use constantly. They claimed that the right to acquire firearms is merely an ancillary right, something secondary or derivative from the core Second Amendment guarantee, and therefore subject to greater government restriction than the primary right to keep and bear arms. The DOJ shut this argument down with extreme prejudice, and their reasoning exposes the intellectual bankruptcy of this entire line of thinking. The brief states clearly, you cannot keep or bear arms without acquiring them first. This isn't complicated philosophy. This is basic logic. No acquisition means no ownership. No ownership means no ability to exercise the right. Courts across the country have already recognized this fundamental principle. Yet Massachusetts attempted to claim acquisition is somehow separate from and less important than possession. The DOJ makes it crystal clear that the Second Amendment necessarily includes the right to acquire arms, and any law that prevents acquisition of commonly used firearms violates the Constitution just as directly as a law that confiscates those firearms after purchase. This matters profoundly because anti-gun states have been trying to regulate the Second Amendment out of existence one step removed at a time. They can't ban guns outright anymore after Heller, so instead they ban the ability to purchase guns, or they ban the ability to carry guns, or they ban the ability to use guns for self-defense, all while claiming the core right to keep and bear remains technically intact. The DOJ just rejected that entire framework and confirmed that every step in the chain of exercising Second Amendment rights receives constitutional protection. Hit that subscribe button right now and drop a comment telling me if you live in a state with a handgun roster or similar scheme. Share this video because mainstream media isn't covering this development even though it could reshape gun law nationwide. Now, examine the actual facts because the Department of Justice brought receipts that demolish any claim that the firearms Massachusetts bans are somehow rare or unusual. One category of firearms directly affected by Massachusetts's roster scheme is Glock handguns, literally among the most popular and widely owned firearms in American history. According to ATF manufacturing data that the DOJ cites directly in their brief, hundreds of thousands of Glock pistols are manufactured every single year. They consistently represent 7 to 9% of all pistols produced nationwide. They are carried by law enforcement officers across the country. They are owned by millions of law-abiding citizens. They have been tested extensively in real-world conditions for decades. You cannot seriously argue with a straight face that Glock handguns are rare, unusual, dangerous, or outside the scope of common use by law-abiding Americans. Yet Massachusetts bans many Glock models from commercial sale within their borders. Generation 4, Generation 5, and Generation 6 Glocks, modern firearms incorporating safety improvements and technological advances, are prohibited from being sold by licensed dealers in Massachusetts. That alone, according to the DOJ's brief, is sufficient grounds to strike down this entire law as unconstitutional. When you're banning firearms that represent 9% of an entire category of weapons, firearms that are provably in common use across America, you are violating the Second Amendment. The Supreme Court has said this repeatedly, lower courts have confirmed it, and now the Department of Justice is stating it explicitly in federal court filings. This case isn't just about Massachusetts, and that's what makes it so significant for gun owners nationwide. If the First Circuit Court of Appeals follows the Department of Justice's reasoning, and they absolutely should based on binding Supreme Court precedent, this decision could undermine handgun roster schemes in every state that operates them. California has a roster, Hawaii has restrictions, New York has approval processes. All of these schemes operate on the same unconstitutional premise, that state governments can pre-approve which commonly used firearms citizens are allowed to purchase. This case could blow massive holes in all of those systems. It could reinforce nationwide that acquisition bans are just as unconstitutional as possession bans. It could reassert that the Second Amendment is not negotiable, not subject to state-by-state reinterpretation, and not dependent on whether local politicians approve of particular firearms. What we're witnessing is the federal government itself admitting that states have gone too far, that the Constitution draws clear lines, and that Massachusetts crossed those lines so egregiously that the DOJ felt compelled to intervene in litigation to protect constitutional rights. Think about what that means. The executive branch of the federal government is telling federal courts that a state government is violating the Constitution and needs to be stopped. That doesn't happen casually. That represents a significant shift in how the federal government approaches Second Amendment enforcement. Gun control doesn't usually arrive in the form of outright bans anymore because advocates learned that direct prohibition triggers immediate constitutional challenges and public backlash. Instead, modern gun control comes through rosters that limit which firearms you can buy, through permit systems that make ownership prohibitively expensive and time-consuming, through pre-approval processes that give bureaucrats veto power over your constitutional rights, and through countless bureaucratic choke points designed to make exercising your rights so difficult, so frustrating, so expensive, and so legally risky that most people simply give up. But the goal remains identical, regardless of the method. Prevent as many Americans as possible from exercising Second Amendment rights while maintaining plausible deniability about whether you're actually banning anything. The beauty of these schemes from a gun control perspective is that they let politicians claim they support the Second Amendment while making it functionally impossible to exercise. They can point to the technical legality of gun ownership while ensuring that, in practice, most people can't access most firearms. Today, the Department of Justice said no to that entire approach. They said hell no. They called it what it is: unconstitutional infringement that violates binding Supreme Court precedent. Now it's up to federal courts to enforce that constitutional requirement, and it's up to American citizens to ensure the answer sticks beyond this one case. The implications extend far beyond legal technicalities about firearm rosters. This represents a fundamental question about whether constitutional rights mean anything in modern America. Can state governments simply ignore Supreme Court precedent they don't like? Can they restructure their laws to accomplish through regulation what the Constitution forbids them to do through prohibition? Can they force citizens to choose between exercising their rights and living in their home states? For decades, the answer has effectively been yes. States have been violating the Second Amendment with impunity, while federal courts twisted themselves into knots trying to avoid enforcing clear constitutional requirements. The Bruen decision was supposed to end that era by establishing that the Second Amendment receives the same rigorous protection as other constitutional rights. But state governments responded by doubling down on regulatory schemes designed to circumvent Bruen's requirements. Massachusetts kept operating their roster system, California expanded theirs, New York created new obstacles, and federal courts in many jurisdictions continued deferring to state gun control schemes despite Supreme Court precedent demanding strict scrutiny. What makes this DOJ brief so significant is that it represents the federal government finally saying enough. The executive branch is telling federal courts that they need to actually enforce the Constitution instead of finding creative ways to uphold state infringements. Whether courts will listen remains to be seen, but gun owners now have the federal government itself arguing that these schemes violate constitutional rights. This fight is far from over, and anyone who thinks one DOJ brief will suddenly fix decades of constitutional violations is kidding themselves. State governments will continue pushing gun control through every available mechanism. Courts will continue struggling with how aggressively to enforce Second Amendment protections. Politicians will continue claiming they support your rights while voting for laws that destroy them. But this moment matters because it represents a potential turning point in how the federal government approaches state-level gun control. If the First Circuit rules correctly based on Supreme Court precedent and DOJ recommendations, it sends a signal to every other jurisdiction operating similar schemes. If they rule incorrectly and uphold Massachusetts despite the DOJ's intervention, it confirms that constitutional rights only exist to the extent courts feel like enforcing them. Either way, gun owners need to understand what's at stake and stay engaged in this fight because nobody else is going to defend your rights for you. The mainstream media won't cover these cases fairly. Most politicians won't prioritize constitutional rights over political expediency. Courts won't automatically enforce the Constitution without pressure and scrutiny. It falls on informed citizens to demand accountability and defend the constitutional framework that protects everyone's liberty. Subscribe to this channel for ongoing coverage of cases like this that actually matter for your rights. Share this video with everyone you know who cares about the Second Amendment. Drop comments demanding that courts follow the Constitution instead of political preferences. And stay vigilant, because the fight for constitutional rights never ends. It just moves to different battlefields with different tactics. What happened in February 2026 with this DOJ brief could represent a major victory for gun rights, or it could be another disappointment in a long series of governmental failures to protect constitutional guarantees. The outcome depends on whether courts do their job and whether citizens hold them accountable for doing it.